Yeah, good afternoon to all of you. And myself, Rakhi Tyagi. Today's my topic is frauds related to documents, a review of Indian Penal Code. Well, you all know what is the frauds. Frauds are related to many kind of the things. In as we are the law students and the forensic students in this session, and we must know about the fraud and the documents. Well, first of all, we will study about the documents. What kind of the documents these documents we are already given in provisions in IPC evidence and as well as the general clauses of Act in law. So first of all, what is document? A piece of written electronic matter that provides information or evidence or that serves as an official record. As usual, anything which is in writing or in the printed form, that is called a document. That is not depend on kind of the matter it is or which substance it is embedded or where it is written. The document, it might be a paper document, might be a writing or the letters or something, figures, marks, they are included into the document. Now, under section of clause 18 of the General Clauses Act, that is, document shall include any matter written, expressed, or described upon any substance by means of letters, figures, or marks, or by many more than one of those means which is intended to be used or which may be used for the purpose of recording that matter. All the letters and the figures and marks are the document, but the most important thing is that the purpose of this document is to the record, and this record is the document is a substantive piece of a evidence. So something is wrong. Is on, I guess. Now, the next definition is covered under section 3 of Indian Evidence Act, that is, document means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means intended to be used, which may be used for the purpose of recording that matter. That means all the letters, figures, and the mark of anything, that is a seal also, you can use as a document. If the seal is put on the document, that is also a part of the document. Now, some illustrations are given under in Evidence Act, that is, a writing is a document, words printed as a document, photographs are the document, map and the plans is also a document. The inscription plates of the metal or the stones, if the someone is writing on the wall and writing by the stone, that is also a part of the document. Caricature is also a document. Now, there are two types of the documents under Evidence Act, that is public document and private document. Public document is covered under section 74. That is, public documents are at large. That means a public officer, anyone can be access those documents. These are public documents. But where the documents are not, there are the documents are, I think is the issue with the network. Is I am audible? Section 75, the private documents are the documents which are prepared between persons for their usual business transactions and communication. These documents are not the public documents. You cannot access these documents via a public person. These are not public at large. These documents are just for the personal use and the personal transactions only. For example, public documents like your FIR is also a public document because you can access a document or applying a application or the certified copy in the courtroom and anywhere else. You can get the FIR copy, or you track the FIR copy. Online system also now is available. But in some cases, there are exceptions also in the provision of the FIR, that is the civil offences cases. You cannot access the as a public document of those kind of the cases. Now, next we will move to the Evidence Act. There are two types of the evidences. First is oral evidence, second is a documentary evidence. First is the oral evidence. You all know this is the oral testimony where you can orally give your evidence. Second, that is more important evidence. The second one is documentary evidence. Now, documentary evidence is a important part. This is a document where this will use in the civil matter as well as in criminal matters. Civil matters, most of the students are in a law background or the forensic students also. The civil matters where you can apply a civil procedure code, and your criminal matters are where CRPC, criminal procedure code are applying. Your IPC, your penal code, that is in the criminal procedure code or the criminal law, there only a penalized system. That means you can a punishment to the accused. Civil matters, there is only you can claim damages and you can claim your recovery process. Now, documentary evidences are two types of the documentary evidences. That one is primary evidence and second one is secondary evidence. Now, what is primary evidence? Under section 62, the primary evidences are such evidences which are original documents. These are not the photocopy or the certified copy. These are the original one. And this is the admissible without any prior notice or anything, and you cannot raise an objection on primary evidences, where section 63, that is a secondary evidence, these are not the primary evidence. That means these are not the original documents. These are the photocopy and the certified copy. Certified copies are those documents which are certified by the authority on the behalf of the original copy from the gazetted officer or the authority which is under law. Then section 63, the secondary evidence is considered to be the inferior type of the evidence, where in the secondary evidence there are some doubt arised between the parties that they may be a false documents, or there may be some alteration or something else in this document. So this is not acceptable. This is acceptable only the condition where original document is not available, like the original document is destroyed and not able to give the authentication or something else, but secondary document you must give the authentication, or maybe question raised on this that evidence is not a first, or it's a authenticity, the question raised on the authenticity of that document. As you all the forensic students know about the forgery, how to do that, or how to compare, and how you can analyze the forgery. Easily you can make a false document by a if you have some piece of document, you can alteration or you can addition of something. So that's why the secondary evidences are not acceptable under in admissible in court. Just there are some prior notice, or you must be proved that the original document is not available or the primary evidence not available. Now, under section 29 of IPC, the document definition is also there. That is, the word document denotes any matter expressed or described upon any substance by means of letters, figure or marks, or by more than one of those means intended to be used or which may be used as evidence of that matter. That means the documents which is expressly or described, expressly means which is communicate to for the communication purpose. Under section 29 of IPC, the word document denotes any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means intended to be used, which may be used as a evidence. Anything which is letters, figures, marks, or anything which is on substance, that means is a document. This explanation 1 says that it is material by what means or upon what substance the letter, figures, marks are formed. This is immaterial. Say that this letter is embraced on wall, or it is written by a stone. That's not a piece of evidence, but this explanation expressly says that this is immaterial. What means that? Means your writing instrument, and what substance, that is where you the letters, the figures, and the marks are formed. These are also a document, and which is, and it is not and it may be uh, court of justice. It may be used as a evidence or not. That is discretion of the court. This document will be admissible or not. That is discretion of court. Now, for example, illustration. A writing expressing the terms of a contract which may be used as evidence of contract is a document. Yes, that is a document. A check upon a banker, a document. Yes, on the check, if you give some check to a person with your signature, that is also a negotiable instrument, and that is a piece of evidence. If the signature forged or something else, then that is also a piece of evidence or document. Now, explanation second, that means whatever is expressed by means of letters, figures, or marks are explained by mercantile or other usage. That means anything which is letters and the figures are explained by mercantile. Mercantile is your corporate law. That is, it's also include the negotiable instruments, that is bill of exchange, that is promissory notes, and the checks. These all are included into the mercantile law. Now, next one is fundamental elements of crime. Now, we must understand what are the elements to form a crime. We all are saying about that this is the forgery, this is a fraud, this is a murder or something else. But what are the fundamental elements which are constitute a crime? Well, in Indian IPC or the Indian Penal Code, 4 types of the elements of the crime. That is, if the crime is done or offense is happened, then the 4 elements are must be there. First one is the crime done by the human being. That means if animal did the crime, that is not constituted in the category of the crime. That means first of all need a human being. That crime is must be conducted by the human. Second one is mens rea. Mens rea is a guilty mind or our intention to be a guilt or intention, evil intention. That means this is the second, the most important ingredient of the crime, element of the crime. That means mens rea. What is a mens rea? It is a guilty intention. It's a guilty mind. It's a evil intention of the mind. It's a state of the mind. It's constitute a crime. If you thinking about to do something with the evil mind, your intention is bad. That is your mens rea. Third element is actus reus. Actus reus is any act, any physical act which is done by a human or a consequences of your act. That means if I say okay, murder is happened, then murder after the death, that is the act of the consequences of your commission of the crime. That means a death is your actus reus, and the bad intention is to murder. Uska hame sorry. Then fourth one is injury. Injury to another human being. Injury, it may be something loss or something damage to another person. That is, it may be a physical injury, or it may be a to harm a reputation, or to harm a damage to the property, or wrongful gain or wrongful loss to some person. Some injury must be happened. Now, these are 4 elements of the crime. Now we will forward to our main topic, that is a fraud or the forgery. These elements are also important for the forgery, that means a human being must be need to do a forgery. Second, intention. Intention is a very important and the element for the forgery. You must prove that prosecution must be prove that the person must be guilty to do that forgery. That means a guilty mind, a state of mind, the intention is a bad to do some act. Actus reus is not necessary in the forgery just because actus reus is a physical act, or maybe some injury happened to some person, or in fraud it may not be happen to another person. Let's do the definition of this forgery. Offenses related to the documents which covered under IPC in section 463 to 4771A. First of all, we will go for the forgery. Forgery is under section 463. That means whoever makes any false document or false electronic record. Yes, false electronic record is added in IPC when the IT Act amended. When IT Act is come and amended, then IPC also amended to the electronic records, or part of a document with intent to cause damage or injury. That means whoever makes any false document, if one person make false document or false electronic record or part of document with intent to cause damage, that means intention to cause damage or injury to the public or to any person, or to support any claim or title, or to cause any person to part with property, or to enter into any express or implied contract, or with intent to commit fraud, or that fraud may be committed, commits forgery. That means if you can understand the definition of the forgery, first of all you need to understand the section 464, that is making making a false document. That is defines in the key way which a false or incorrect electronic record or document can be made. Now, what is making a false document? We all know what is a false document. False documents are not authenticated, right? So the definition is clearly mentioned that three ways in which false document or incorrect information is providing in document. First, by making or reviewing, signing or executing a document or the part of the document and transit to the person, or adding an electronic signature to any electronic record. That means making a false document, modifying or any alteration in sign, seal or any part of the document. Even if you make a new document as it is, that is not authentic, but you make a whole document new, it's also amount to a forgery. Now, the definition, I think this definition is clear. Then second is false document comprehends creating a new document, making document by mechanical means. That means if you mechanical means that is your photocopy or some mechanical process is used and making a false documents. This is a making documents by mechanical means. For forging a document by affixing own signature. If a person sign his own signature and says that, but the intention and the evil intention is the wrong or the bad intention of his of that person and making a signature to fraud to with another person or to damage to another person, it amounts to a forgery. Now, these are some forms of forgery. Forensic student taught me about these kind of the forgeries, and first is stimulated or the copied forgery. Copied forgery means if someone copy a signature of some person. Second, traced by a tissue paper or a butter paper or a carbon paper. You can trace the signature or the handwriting part on the document. Now, forgery by memory. If you remember some signs, how he make a signature, and you are just memorize that signature and just put with the intention to forgery, then it amounts to a forgery. It's a form of forgery. Now, forgery by impersonation. Impersonation is the impersonate. That person is not the real one and just do a forgery with the name of some, maybe a imaginated person, or maybe a person who are actually in the real world, but not that person is not the real one. He just impersonate himself. I am that person and I'm just doing with reason to believe that this is I am the correct person and to do this, execute the document. Now, nature and the scope of section 463 and 464, 465. 463 says that the accused, we already discussed this definition earlier, that is a forgery. That means the accused must have made a false report or a copy of something, or to fabricate a document, an electronic record, or to put anything, or to alter, to making, or anything else. And you can say that this is a forgery. Also have to demonstrate that, as the case may be, the report or electronic record was forged to satisfy any purpose of the mentioned in section 463. Now, uh, the section 463, as described already, we discussed the important ingredients earlier. That is, with the intention, causing a damage or the harm, making a false document or electronic record or part. That is your 464, sorry, 463. And entering into express or implied contract. Express or implied contract means you are expressly do a contract. Expressly implied contract, this is the part of the contract in Indian Contract Act. That is, express, you are in writing or communicate via orally. Implied, you are just give by your action. That is express and implied contracts. Now, section 464, making a false documents, we already discussed this. And the punishment of the forgery is given under section 465, that is 2-year imprisonment or fine, or maybe both. This is a non-cognizable offense and bailable 2-year, and first-class magistrate will try these kind of the matters. Now, there are some aggregated forms, that means forgery involved in this, and what these are the aggravated form of the forgery. These are included under section 466, that is forgery of the courtroom or public register. If you are doing something forgery in court record, or you public register, that is a public document. They are talking about the public document. You can access these documents from public documents from the registrar office. These are the public documents. And for example, registry of a birth, death and marriage certificates, or by a public servant, or a certificate or document intended to be made by a public servant in his or her official capacity. You are just fabricating these kind of the documents in by the public servant. Then this section will attracted an authority to dismiss or prosecute a claim or to take any action therein, or to grant judgment, or a power of attorney. Power of attorney, this is also a kind of the document, and you may be some forgery in this kind of the document. It will attract to this section. Next section is 467, that is forgery of valuable security. Now, what is valuable security? Valuable security are those documents which are comes into the like your will, your check. These are the lawful guys, we will take your questions later on. I'll just go ahead. We will discuss these questions. Now, valuable securities, like your check or the promissory note, is a valuable security. The legality of these kind of the documents are the valuable security. A registered deed is also a valuable security. And will also as a testamentary document. If this is a registered, or then it's a valuable security. The punishment for the life imprisonment or imprisonment for up to 10 years and also fine. This is the punishment for the 467. Next है forgery for the purpose of cheating. If you are talking about the cheating is also cheating is covered under section 416 under IPC. Cheating and the forgery, there is a difference between the cheating and the forgery. Cheating is most probably for the movable property, comes under the another chapter in IPC, and forgery is covered for the documents only. So because in the forgery you can fabricate your documents, that's why it's covered under document related offenses. And the cheating is for movable objects and the immovable property, like cheating it to dishonestly or fraudulently to induce something and to deliver something, one person to another person. One person if induces to deliberately or to fraudulently to deliver some movable property, then it comes under in cheating. So forgery for the purpose of cheating, under section 468, the punishment for is 7 years and imprisonment and fine also. Next one is forgery for purpose of harming reputation. I already discussed that the injury is maybe injury, if you fundamental of elements we are already covered, that is covered under into the injury to for the property, for your body, and to harm your reputation. So reputation is covered under this section. Reputation is also called a defamation case, but forgery, so many sections are attracted in this case also, for forgery for purpose for harming a reputation. If one person just to create a document for harm a reputation of the person, it this section will attract it. Next one is using as genuine a false document or electronic record. If one person genuine documents will forged, genuine document will forged means कि false documents are what? False documents are fabricated or falsely making a documents. So this section will make attract. Now we are already we just talk about the cheating. Cheating is section 415 cheating. Whoever by deceiving any person fraudulently or dishonestly. Now for this section we must know about the fraudulently and dishonestly. In IPC, there most of the definitions are covered under IPC. Fraudulent and dishonestly are covered under section 24 and 25. 24 is fraudulent, that is 24 is dishonesty. Whoever does anything with intention of causing wrongful gain to one person or wrongful loss to another person. If one person gaining something with an intention to one person wrongful loss to another person, this is a dishonesty with an intention is an important part. Now second is fraudulent. Fraudulent means a person is said to do a thing fraudulently if he does that thing with intent to defraud. Again it's an important part is intention to fraud or to defraud but not otherwise. In IPC, whole IPC, there is no definition of the fraud is covered, but fraud means using to trick, dishonesty, make a personal gain for oneself. If one person deceiving someone to just wrongful gain something and to damage something with an intention or to deceive a person or to induce a person for wrongful gain, it's a fraud. Fraud is covered under section 17 of Contract Act, but not covered under section not covered in IPC. So we are moving on. Section 420. Definition of the cheating is covered under section 415, but the punishment of the section punishment for the cheating is under section 420. You most probably hear about the that person booked under 420 case. So that is a cheating. Whoever cheats shall be punished with imprisonment of either description for a term which may extend to 1 year, with fine or with both. This is also bailable offense and non-cognizable offense. Now section 472 in IPC, making or processing counterfeit seal etc. with intent to commit forgery, punishable under section 467. If any one person to making or processing counterfeit means something false or fabricate a seals or the stamps, you can say a stamp we are using, these are the counterfeit seals with the intention to commit forgery, then this section will attract, and the punishment is for up to 7 years. Whoever makes or counterfeits any seal, plate, or other instrument for making an expression intending that the same shall be used for the purpose of committing any forgery. So that this is an important part. This counterfeit seal is used for the forgery only. We are already talk in forgery definition. there is a process, sign, and the seal covered under forgery. If you are using or making a false documents, then these may be something falsely making the document. Whole document is maybe if you are making a new document, and maybe that is totally a new document, that is also it amounts to a forgery. But if you are just counter a one part, or only put a one signature, or just remove a signature from that document, or to alter, or to make a signature, or to make a seal or a stamp on the document, that is also amount to a forgery. Then this, if you are using or the process make a counterfeit seal or the stamp, then this section will make a trap. Now there are other provisions also. You can read offense related to the property marks. Property marks means your stamps or trademarks, these are covered under this provisions. 479, 481, 82, 483, 484, 485, 486, 487, and 488. These are the property marks. Now, how a case to be initiated and so on. First of all, if the cheating or a forgery happened, you must lodge a FIR or a complaint to a magistrate under section 154 of CRPC, or complaint. If the FIR is not acceptable by the IO, you can go for 156.3 of CRPC and complain to the magistrate. Second step is that is not the part of yours, that is a part of the IO officer, who will investigate and collection of the evidences, or the collect the data. Okay, what kind of the evidences he can search. Now, charge sheet might be filed by the IO to the magistrate, and in the charge sheet there is the most of the documents and the statements are given of the accused and the victims, and many of the documents are covered under charge sheet. Then trial begins after taking a cognizance by magistrate. Now magistrate must take a cognizance. Cognizance means that a judicial mind to be applied. A magistrate must apply a judicial mind. That means that case will initiated or dismissed. That is a cognizance. Cognizance may be taken by the FIR on the complaint case, or suo motu. Suo motu by itself. Evidence. Then next stage is evidence. Now after the arguments and the trial begins from the charge. When the charges start and make the charges, if you're booked under section forgery or in the cheating, then the charge put by the magistrate, and then evidence comes apart. Evidence from the both the party, from the prosecution and the defense. First, case begins from the prosecution side. The first of all, the prosecution evidence firstly open, and then defense evidence is comes enter into this stage, and as well as the expert opinion is also comes under this this stage only. If the cross examination and all these things are covered under this stage, then arguments between both the parties from the prosecution and the defense side. After that, final judgment and acquittal or conviction basis on the judgment. Next, when we are talking about the collection of evidence, the IO may be search and the collection of documents. What kind of the documents he may be take over, or this is the some list for the documents how to where is search and collect the data. That is registers carrying details, money, accounts books, phone bills, etc., which is the related to the related documents according to the case to case. Now, material evidences are like your pen, pencil. Forensic student must be know about these things. So, computers, desktop, laptop, if anything, CCTV footage, videos, still cameras, etc. Stamps, seals, ink pods, etc. So, these kind of the evidence which will go to the FSL or to the private experts just to compare the things, preservation of the document, question document and standard documents, and then comparison between these documents. Now, here's some 2 or 3 cases related to the forgery. 2 cases which I am discussing, these are not in the PPT. One is Province of Bihar versus Surendra Prasad. In this document, in this case, a new document is also a forgery. A person make a whole new document, but with an intention to do a forgery, it amounts to a forgery. In this case, they decided that a new document is also a forgery if the intention is to forge and the legality of that document is to be forged. Next case is that LK Sidappa versus Lalithama. In this case, a accused make a marriage card invitation, the name of the girl, which is and circulated the marriage invitation card, and that marriage is not to be happened in future, and the girl is not ready to marry, and without her consent, accused distribute the cards, and in this case decided that the marriage card or this document is also a forged because this document is not consent with the girl, and this is the intention to fraud with that girl. Now, next case is Dr. Vimla versus Delhi administration. In this case, Dr. Vimla and the Nalini is the daughter of Dr. Vimla. She is Nalini is a 6-month daughter. Vimla is take a insurance policy and with not a bad intention, with a good intention, and after some time there was some mishappening happened with that family, and Vimla did signature of the Nalini in policy just to execute that policy and to take the amount from the insurance. Then in this case, no forgery because no damage caused to someone else, because this insurance taken by herself, but the contention of the insurance company is that Nalini is the 6-month daughter and she cannot sign herself. So in this case, there is a matter of the guardianship also, and yes, she can make a signature on the behalf of the daughter of the Nalini, and this not amount to a forgery. Then in this case, Sheila on the PPT, Sheila Sebastian versus Jawahar Raj. Supreme Court in this case ruled that command of forgery cannot be imposed on a person who is not a make of the same. Forgery cannot be said that that person commanded to do a forgery. No, that is not amount of forgery. If that person knows about that thing, yes, he did a forgery and with the intention to do a forgery, then it's amount to a forgery.
The court also held that until and unless the component of section 463 are satisfied, an individual can't be convicted under section 465 by solely. If the ingredients of the forgery are not supposed to attract this section, then no offense of the forgery. If the intention and other elements are attracted to this section, then it amounts to forgery. So the intention is the most important part of the forgery. Next case is Ibrahim and others versus the state of Bihar and others. It is a landmark case where the Supreme Court stated that a person is said to have made a false document if he made or executed a document claiming to be someone else. If person says that I didn't execute this type of documents, if he altered or tempered a document, he obtained a document by practicing deception or from a person not in control of his sense. If he not doing the forgery, if he don't know about the document is executed, but the Supreme Court also held that to get a condemnation under section 465 of IPC, false document must have been made with an intention. If the intention is there, then it amounts to a false document. If that person used that document just not for the bad intention, that means no forgery is happened. Now the conclusion of this PPT is the section 463. The important part is intention, essential part. 5 situations are provided in this section. The intention is the essence of the offense of the forgery to constitute it. Some damage, injury must be intended to cause by false document. The injury or the damage of another person happen from that document only. If that document not harm any person or damage any person, then that is not attract to this section. Section 464 is stated that the act should be done dishonestly or fraudulently. The act must be dishonestly, wrongful gain, wrongful loss, fraudulently to intend to defraud. These both are the mens rea of this section. And conclusion part is that the burden of the proof is on the prosecution to prove the intention of accused beyond a reasonable doubt. In the criminal law, you must aware about this thing. Ki prosecution must to prove the intention. That means a mens rea of the accused beyond reasonable doubt. Yeah, obviously, an expert can help or adding knowledge of the document comparison and other things to into the evidence part in criminal justice system. Document is a important and a substantive piece of evidence in criminal and as well as in civil cases. Is the essential element of the offenses as well as in the civil matters. Thank you. Now you can ask. I hope this PPT and the session is interactive and helpful for both forensic and law students. Now you can ask questions. Question is how you can prove the criminal mind is guilty in the forgery. Madhvi ji, देखिए इस Madhvi ji, in the criminal mind, it's a very hard task to prove a guilty mind of a person. That's why a criminal law, it's must be proved beyond reasonable doubt. That is, all the burden of proof is on prosecution side. If and the burden of proof, it may be shifted to the another person or the defense person. If you establish your case full proof with the evidences and other things, then you can easily uh, prove that the person is a guilty mind. uh, Now आप अपना you can ask the questions.
Does any of you have any questions to the speaker? Okay, so I don't see any questions from the participants.
Okay.
So yeah, with this, Rakhi, I thank you very much for your time and sharing your topic with us. So I believe participants definitely would have benefited from your topic.
Thank
Okay.
you, sir. I think some issues between the network issue, but I just hope I give my 100% in my PPT, and the topic is must be clear to the students.
Yeah. Anyway, thank you very much, Rakhi, and participants. Thank you for the participation, and we will get back to the session at 4:30. We have the session on how to enhance the audio recordings and what is the validity of such audio recordings to be used as evidences. Okay, so we'll have Mr. Rajiv S. Joyce, who will be teaching us as to how and what are the challenges we would face from the recordings of the audio. Sometimes we record the audio from the mobile phone, sometimes a telephone recording. Okay, so a lot of things we will be discussing in the session there. So we'll get back to the session at 4:30. Thank you very much.
Thank you, sir.
Yeah.